Inclusive juries. Access for people who are deaf, hard of hearing, blind, or have low vision. Community survey. You can respond to this survey by typing your responses into this document and emailing it to us at juries@lawreform.vic.gov.au, or by recording your responses as an audio or video file and sending it to us. 1. Do you have any experience of not being able to serve as a juror in Victoria because you are deaf, hard of hearing, or blind, or have low vision? What happened? What happened? If you were not able to serve, was it because you were discouraged from joining or remaining in the jury pool, or were you excused by the judge or Juries Victoria, or for some other reason? 2. What type of supports might people who are deaf, hard of hearing, need to serve on juries? And what would be the best way to explore those needs with the court? For example, support people, Auslan interpreters, captioning services, magnified documents, assistance animals, and a tour of the courtrooms. 3. Should people who provide support or Auslan interpretation to the juror during the trial be required to provide an oath to court to keep discussions confidential and not to get involved? 4. What do you think some of the misconceptions of the community about the ability of people who are deaf, hard of hearing, blind, or with low vision to serve on a jury? 5. Are there circumstances where vision or hearing loss may mean that it is not possible for a person to serve on a jury because of an inability to comprehend evidence that is likely to be critical to the verdict? For example, assessing voice or visual identification evidence like CCTV footage, phone messages, or the truthfulness of a witness. In the consultation paper, we give the hypothetical example of a trial where the key issue to be determined by the jury was whether the accused was the person who left a phone message. There was no other identification evidence presented. We also provide the example of a case in America that examined the extent of a victim's injuries. The judge held that a blind juror could serve because identification of the accused was not an issue, and the juror was able to determine the extent of injury through doctors' reports and the testimony of the victim, and not just by looking at photos of the person. 6. If a potential juror cannot serve on a particular jury because of the nature of the expected evidence, should that person return to the pool and be able to serve on another trial with a different type of expected evidence? 7. If the law changes to enable deaf, hard of hearing, blind, or with low vision to serve with reasonable supports, should there be a right to be excused because of disability? Or should a person who is deaf, hard of hearing, blind, or with low vision only be able to be excused on the same basis as everyone else in the community, on a case-by-case basis, and for good reason? The current law provides people with disabilities the option to seek to be excused from jury service on a permanent basis. The law also provides excuse for good reason on a non-permanent basis, including because of illness, poor health, or hardship. 8. Do you have any other comments to make about the issues raised in the summary or consultation papers, including changes to legislation and practice?